what is estate planning and why is it important? We will be interviewing Aliyah Jaggassar Hamel-Smith of ExeQtrust Limited. So welcome, Aliyah.
Thank you.
Welcome to our video series here at Terra Caribbean.
Thank you very much. I think this is an excellent initiative you're doing.
Yeah, lovely to have you here. And we want to hear a little bit more about ExeQtrust and how you got into estate planning, opening your own business.
Sure. So I've spent the bulk of my career, as you know, at RBC. Headed up the trust company. That's where I developed my love for will preparation, probate. And then I became the regional vice president. So I got responsibility for Bahamas, Barbados, Cayman Islands. And it was interesting to see the sort of offshore trust structures they have there versus the domestic trust in Trinidad. So if someone wants to leave their assets to their beneficiaries and their minors, a trust fund would have been the thing to do back in the day. Our legislation in Trinidad has changed a lot, so that's not very common. Leaving it via the will is the preferred option, but again, depending on each situation, that can be done. Also develop a real deep understanding of the pensions landscape in Trinidad, so the importance of it, difference between pensions, annuities, old age pension, NIS, all of those things that we at our age still kind of take for granted, but the importance of them rounded that off. Then I became the CEO at an insurance brokerage where I really got an in-depth understanding of the life insurance sector, the importance of health insurance, and of course the annuity. So sort of rounded off my whole financial planning, estate planning learnings. And then COVID happened.
Yeah.
And I'm sure you know as well, with two young kids, so trying to balance that online school for a 4-year-old and a 7-year-old, being the CEO at a very dynamic company, I kind of got to that self-searching place. And it was so interesting. People that I hadn't spoken to in years kind of reached out about wills. And COVID really questioned our mortality. About setting up their pensions and what did they have and was it going to be enough, and then of course unfortunately when people did pass away from COVID, how to transfer their assets onto their loved ones. So I got a lot of calls, and I kind of almost felt like the Lord had led me to where I was with all the experiences that I had had before, and sort of opened this path to me, and yeah, that's how ExeQtrust was born.
It's quite often unfortunate circumstances, right? But it's inevitable. So we have to think these things through from the early stages. And we see it quite often in real estate where people will buy a property and not really know the best way to vest the property. If you're buying for a husband and wife, or if you're buying with your children in mind. So, maybe you could elaborate a little bit more on that.
Yeah, so and that's the whole ethos of ExeQtrust is holistic estate planning. Right, so to help you understand from the beginning when you're acquiring assets, how to own it, what are the different types of joint ownerships and which one applies to you, because it's not a cookie cutter approach. Every situation is different.
Correct.
And then that's where the financial planning side comes in. So how to maximize what you have now so that you can enjoy it. We're not just working, to leave everything for our children, but to enjoy it now. And then what are the most tax efficient and cost efficient ways to leave it for who you want to leave it to, which does not necessarily have to be your next of kin. So, that was a great question, because you in this line of business would see that a lot. Just this week, I had someone who'd had a property that she and her brother own, but they own it as joint tenants. She's come to me to do her will. A joint tenancy situation is absolutely not favorable in that type of scenario, because if she were to die first,
Great. So maybe you could talk us through a joint tenant situation and a tenants in common situation, because that's really important to understand at the buying stage of the process.
Exactly. And so those are the two types of ways you can legally own property jointly. So because they own it as joint tenants, in the sector, we kind of easily refer to it as the last man standing. So whoever is the last man standing would be the 100% owner of that property. So she's come to me to do her will, but if she dies en route home, then that brother becomes the 100% owner of the property. So whatever she said in her will doesn't have any relevance because she doesn't have an interest, a legal property interest in that property.
That would be a joint tenant situation.
Correct.
Whereas tenants in common.
So what they should have done, what the lawyer should have done when he was vesting that property in the two siblings, should have done it as tenants in common, so that each of them would end up with a 50% legal ownership in that property, whether they're alive or not.
Correct. Very good. So then we jumped into joint tenants and tenants in common, but maybe we should speak to a will. I mean, will is something quite easy to do.
Right.
I understand you guys have an app where you can do this online. That's awesome.
Yes, I'm so excited about it. It's the first online will generating app for Trinidad. So it's built to our legislation and our requirements, where the user can put in, again, their names, the name of the property, who they want to leave it to, and all of that is churned out in the background, and it generates an actual last will and testament in accordance with the laws of Trinidad and Tobago. So, I mean, a will is just one, right? One of many estate planning tools. We just spoke about the deeds and whatnot. But it's probably the most important arsenal in your estate planning portfolio. Because I guess you would have people say, well, why am I going to pay a lawyer to do a will when I just want my spouse and my children to inherit the property? So I think where it really boils down to is what would happen if you die without a will?
Yeah, so maybe you can give us that series of events. So if you have a will, obviously you can structure it as you wish. But if a husband dies without a will, how does it go?
Right. So I'm going to pick on you. I mean, you have 2 young children, they're minors. So by law in Trinidad, they can't hold title to a property, but you can, in a will, say that you want it to go to them. So if you owned your property as joint tenants with your wife, remember what we were just saying, that is more typical for a husband and wife situation, certainly not a brother and sister.
That's where, should one expire, the other is 100% shareholder.
Exactly. So you didn't have a will, and God forbid something happens to you. Your wife now becomes the 100% owner of your home. But let's say 5 years pass and she remarries. Your children are still minors, and then something happens to her. She doesn't have a will. That new husband becomes the 100% owner of that home that you bought.
I don't like this story, Aliyah. Just kidding.
And JP, unfortunately, that is the reality of life.
Sure.
And suppose he goes rogue and something happens, your children may never benefit from that property that you built because there was no will protecting their interest.
Right, so to counter that, I could potentially create a will, which using your app or literally writing a will, having somebody witness it, and it doesn't necessarily need to be registered, does it?
So that's a great question, because there is provision for wills to be registered with our probate registry, but it doesn't really have a huge impact or effect. What it does is that, especially for elderly people who live, let's say, with their in-laws and maybe don't trust them to not tamper with their original will document, having their will registered means that when they die, that the family can trust that that is their authentic last wishes. The complication with having it registered is that you can't unregister it. So, you know, a will is not a static document because you can change it up to the last day that you die. So if, God forbid, you fall out with somebody you've left as a beneficiary in your will and you want to change that, which is very important to do, the only way they can do that is by doing over a second will, but also registering it. And if by that point they're bedridden, they're elderly, they live overseas, they can't physically do it, then it's a complication, and a big complication, because they can't even give a power of attorney to somebody to do it for them. So for my clients, I don't recommend registering it. It doesn't have anything to do with authenticating it. Once you pass on and we have to file the grounds for probate, you have to register the original will at that stage anyway. So registering it up front.
Right. Great. So not really a need to register it, but to be very clear and transparent to where it is and how to access it and be open with your family about it.
Exactly.
So quite often we find ourselves, you know, we bring a buyer to the table and then all of a sudden a probate needs to be done, right? So maybe you could talk us through that. I mean, estate planning, as I understand it, is ideally you're obviously trying to vest the properties in whose name you want it to be after you pass on.
Right.
But also you want to make it easy for them. So you don't want to end up in a probate situation because I know that's never easy. So,
I mean, yes and no, right? There are pros and cons to both. When you pass on and in your will you've left property to someone else, the deed that is done to transfer that property legally out of your name, the deceased, into the beneficiary's name, that is rated at 0% stamp duty. So it turns out to be a much more cost-effective way to transfer property, as opposed to you're going to say, well, during my lifetime, my children are adults, I want to give one this property and the other whatever else. So you want to transfer it legally into that adult child's name. You do that by way of a deed of gift, but then you're going to pay full stamp duty. It's not even discounted, full stamp duty on the value of your property.
Right, so let me repeat that just to ensure that I understand.
Sure.
So what you're saying is, if you leave a property in a will, it passes through the process without attracting stamp duty. But if you leave a deed of gift, it can be subject to stamp duty.
It will be, not can, it will be subject to stamp duty. So it's a much more expensive way. But again, depending on the family situation, I've had clients like with divorces and whatnot that just want to make sure that their children get this property. They're willing to put out the stamp duty to see that deed in their name without having to wait for probate. I guess the downside with probate is it takes a while. It takes at least a year to get that grant, and then you do the deed and you vest it. But it is certainly much more cost effective than having to pay stamp duty.
Right, how interesting. Yeah, because I mean, you referred to COVID earlier, and I don't know that we'll ever stop talking about COVID really, but during COVID, we saw a lot of separations, we saw divorce, we saw death, so it really, again, is something we have to table. But in a case of a divorce, and how, maybe you could talk us through that a little bit.
And it's funny you say that, because marriage and divorce, right? Two sides of a coin. So by law, once you get married, any will that you would have done prior to the date you got married, null and void, not applicable. And because for some reason the law assumes that you've now changed persona because you're now a married person. So the last will that you did, and this is regardless of whether you change your last name or not, because it applies to men as well. The will that you did before you were in a married state or marital state, null and void.
Another reason to reconsider marriage, I'll tell you.
That's a good conversation.
Point. Good to know.
Right. But then when you get divorced, and I think it's more logical for someone to assume, if I did a will, left my property to my spouse, John Smith, when I get divorced from John Smith, that will is null and void. That's not the case. So I've had a situation where the person had passed on 12 years since he passed on 12 years after he got divorced. But in his will, he left a gift of cash to my wife, I forgot her name, and that was still deemed to be a valid gift because they looked at the fact that 12 years had passed and you still didn't change your will. So you maybe still intended your wife, whoever, to get that gift of cash. And so it causes fighting with the family because by then he'd had a new wife. But it wasn't a legal wife, it was a common law relationship. So all of those things are reasons why you must always keep checking back to see what you have, refreshing, reviewing. And as I mentioned, common law, that's another reason why having a will is also important. So common law relationships have valid legal status, but it is not automatic, meaning when you pass on, your wife has a marriage certificate, she can go into the bank with your death certificate and the marriage certificate and authenticate who she is, and therefore she can get the proceeds from your accounts. Common law still have to go to court to be recognized as such.
Right.
So when you die without a will, and I know that's one of the earlier questions we were discussing, it still makes it more difficult for someone in a common law relationship to establish their rights, as opposed to if their partner had done a will saying, to my partner, Jane, that will gives them much more valid rights than having to go to the court to prove a common law relationship when someone passes without a will. They now have to establish their status, as opposed to a wife or children. Children have birth papers. So even if you die without a will and your beneficiaries are your wife and your children, it's still much easier for them than someone in a common law relationship. And I mean, even same-sex relationships, that is also difficult. You're not automatically deemed a next of kin. So when you die without a will, and you're in a same-sex relationship, your partner gets nothing. Whereas if you'd had a will and you'd specify to my friend and you name them, you're good to go.
Yeah, so another reason to have a will, and as you say, to revisit it regularly, because life changes, things change, and you want to ensure that when the time comes that it's a smooth process for your family or friends or common law wife, whatever it may be.
Whatever it may be. So part of what we do, because we have this electronic database now, is that we would reach out automatically every 3 years just to touch base with clients. Has things changed? Has your circumstances changed? Do you want to update your will? I mean, I had a tragic case recently. Someone came to me to see if I could help, and unfortunately I couldn't. The guy was married, she died, wife died, he owned the property. Years later, he got in a relationship with someone else, and her son, so not his blood son, moved in. They lived harmoniously for decades. The woman died, and the son is her son is who ended up taking care of this gentleman. The gentleman passed away, but he had 4 children. these 4 children had turned their back on him. They had never given him a cent. They never took care of him when he was bedridden. It was this the son of his partner who took care of him. Soon as he died, those 4 children took over the property because they were legally entitled to it, and they kicked out the young man who had taken care of their father. And it was someone on behalf of the young man who came to me, but there was nothing we could do.
How unfortunate. So had the older gentleman been corpus mentis, of course, he could have adjusted the will.
Done a will. He didn't have a will.
He didn't have a will at all.
He didn't have a will. So
could have simply done a will, which is, writing down some simple pointers.
Exactly.
Guiding,
Exactly. And those are reasons why I try to make having a will not a laborious or daunting task for people. You can do it via an app now. So in a case like that, this gentleman would have obviously left it to this young man who took care of him, and he wouldn't be out on the streets as he is now, because by law, those 4 children of his are still legally entitled.
Yeah, this is fantastic. I mean, that's why planning on the whole for estate planning is so important. And I think I'm really grateful that you came and spoke to us today. And
sure.
I do believe that Terra Caribbean and ExeQtrust could form a really strong relationship and work together to our clients' benefit.
Exactly.
So maybe you can tell us how we get in contact with ExeQtrust. How do we get you? And
sure.
Should any of our viewers want to reach out?
I definitely will. I think I just wanted to make one other point. I kept saying, there's so many estate planning tools, and some of your agents have chatted with me before about a power of attorney and how we can use that.
Power of attorney.
Right, because I think you would see that a lot. So it's just another arsenal in your estate planning docket, where if you are physically unable to transact business on your behalf, you give someone that you trust to do that for you. So that person can sign deeds to purchase property or sell property on your behalf, or deal with your bank or your investment accounts on your behalf. Usually it's given when the person is physically immobile or unable to do it, or living overseas or out of the country. What I have noticed though is that people come to me and they say, my mom, we've noticed early signs of Alzheimer's, so can we do a power of attorney for her so that when she goes mentally, but she's still alive, we can do things on her behalf. And that's such a misnomer, because by law, once you are no longer deemed of sound mind and body, any power of attorney that you give, null and void.
Yeah, it won't stand up, of
course. It won't stand up. But you see, you know that, JP, because you're in the sector. I think most people don't know that, because they think now is the time to do a power of attorney. There is, in fact, another tool under the Mental Health Act of Trinidad and Tobago, where in that situation, you apply to be nominated as a committee on behalf of that person. But it's a much higher threshold than just doing a power of attorney document in front of any lawyer. You actually have to go to court and be deemed. So you're the same child of the person with the mental disease has to go to court and be appointed by a judge as a committee on behalf of that person. Once you get that committeeship document, it acts pretty much like a power of attorney, but it's just a much higher threshold to get it. And then for obvious reasons, to make sure that the elderly persons are not being taken advantage of, because you're kind of signing away all your rights and powers to this person to act on your behalf.
Yeah. So getting a power of attorney done is really a simple thing. You go and you see an attorney, you sit down, and they would witness you taking instructions to become a power of attorney for somebody, granny, mommy, whoever, right?
Correct.
But the key is to do it early.
Correct.
While they're all corpus mentis.
Exactly. But then it's also to understand that having a power of attorney only lasts while the person is also alive. So I've had other people say that as well. Well, mommy doesn't need a power of attorney. Mommy doesn't need a will because she's already given me a power of attorney. And they think that they could continue to transact mom's business or any bank accounts in mom's name on her behalf because they have the power. But once mom passes,
it's invalid beyond her passing.
Exactly.
Right?
So we have like a timeline drawing that shows the power of attorney during your lifetime. But then when you pass on, that's where your will steps in. So again, all the different estate planning tools you have in your docket or your arsenal, they're all relevant for certain stages and periods of your life. And it's not to say that you need one or you don't need the other, or that you even need all. But that's why you speak to a consultant and you find out which one is applicable.
Yeah, so at any stage of life, families should really get together, come and sit down with you to understand, at what stage you do what, because it's so important to have everything in order
You know, I think you've hit something on the head there as well. Families talking about it. I don't know about you, but my parents' generation, they're very secretive about those things. Like we had no idea what Granny had or owned. And I just found my parents and their siblings don't talk to us about that. But I think now that you and I have young ones, we should change that trajectory. Let them know, have those conversations up front so that it's much easier to plan the estate. Yeah.
Agreed. Let them know what you and your wife have agreed in the will and where the will is located, and include them and have the conversation, so that when the time comes, they're prepared and they understand. They've been sensitized to it.
Exactly. And you just said it, when the time comes. I think people shy away from having these discussions. They think estate planning is daunting, or it's only for when I pass away. But I hope you're able to garner from this conversation that it's a live, dynamic estate planning for while you're still alive, how you can enjoy your assets, how you can transfer them while you're still alive, if that makes sense. So it's not something to be scared of. And in fact, the will is the only estate planning tool that only takes effect when you die. The others, can happen during your lifetime.
During life.
Yeah, it's important that we address all these things now while we still can.
Absolutely, and it's so comprehensive. There's so many different avenues you could take, so you really need to address it early.
Yeah.
Well, thanks again, Aliyah. It's really great to have you. And there's so much more than I thought, right? There's so much more that's available to us, and we're really proud to work with ExeQtrust.
Absolutely.
And maybe you could tell us a little bit about how we contact you.
Sure. So my website, www.exeqtrust.com. That's ExeQtrust.com. And we get access to the app, the will generating app. And I have a lot of information, just a lot of things we spoke about here. I have it in short bullet points, little infographics to help people understand. I'm really big on educating. And I think lots of people are not aware of these things. So it's good to find out.
So they can come sit with you, or you can go sit with them as well, right? So there's a physical option as well.
Exactly.
You're open to face-to-face meetings.
Absolutely. I think the elderly people don't want to do the virtual to talk about things, personal like this.
Sure.
So very, very open to any medium, electronic. The only thing that you have to do in person is sign your will. I mean, for most clients, we did everything virtually, but met in person, all masked up, to make sure that because you have to sign it in the presence of two independent witnesses, which we provide. So part of what we do is we also do 2 original wills to make sure you get one. We give it to you in a nice sealed envelope, but we keep one as well, because we have to file the original as part of the probate application. And sometimes when people move or they travel a lot, they can't find the original, so we keep that one original.
Very good. Yeah, I wish somebody else had originals of all my documents, because when you need it, you kind of hustle and you're not sure where you have it. So it's always good to have somebody else supporting you in these big life decisions.
For sure.
So thanks again, Aliyah.
You're welcome. Thanks very much, JP, for having me.
Anytime.